Greetings of peace. Assalamu alaikum to all of you. Good afternoon. Everyone probably had a chocolate rush, the cookies, a sugar rush. So I'm really grateful to be here, and I wanted to just say a brief word regarding why this conference was important to me in particular, and I'll be very brief about it. I went on an interfaith delegation to Pakistan, and one of the things we heard about there was a lot of concern about American drones. And I think it's important for people to be thinking about, how we, as an American Muslim, I'm an ambassador for this country. And when I hear from my colleagues in faith and community of faith about the concern of my country regarding drones and so many other issues in this global war on terror post 9/11, it really imposes a challenge on us to be effective spokespeople for our community, speaking to our, for the United States, speaking to our community in faith. So anyway, that's just a brief word, but this panel now will be examining the legality and morality of policy positions. And we have three wonderful speakers. Our first speaker will be Professor Mary Ellen O'Connell, who is an author and professor of international law at the University of Notre Dame Law School. She's a senior law fellow of the Center of Theological Inquiry here at Princeton, an expert researcher and a researcher of international law, use of force, and international legal theory. So please come up. Thank you.
I also am very proud and honored to teach at the University of Notre Dame's Kroc Institute of International Peace Studies, where I teach alternatives to the use of force. When Rich Killmer invited me to this conference many months ago now, I said a small prayer of thanks. In January 2006, George Hunsinger asked me to speak at a similar gathering aimed at stopping the use of torture. That conference, as Rich told us yesterday, did lead to important changes to this country's policy of using torture. And I am praying fervently at this moment that this conference will have a similar positive impact, and I'm increasingly confident as the day goes on that that will be the case. But let me be clear, I think our task with regard to targeted killing is even more difficult than with regard to stopping the use of torture. We know that torture had been used in this country from about 2002 on. Pictures were revealed from the Abu Ghraib prison in Iraq showing horrible abuse of persons within US custody. By 2009, President Obama had signed an executive order to end the use of torture. The United States also began targeted killing in 2002. Unlike the use of torture, we knew about that targeted killing with a drone attack in Yemen carried out by the CIA, launching a Hellfire missile from a drone, and that is really where no one has said the word hellfire yet. That's the real problem that we should be focused on. In addition, as Jeremy Waldron said last night, the fact that we're killing human beings unlawfully. We're also using a weapon of war, military force, in non-armed conflict situations. It's not the drone per se, as Gabor Rona said, it is the Hellfire missile. The CIA has no right under international or national law to be carrying out paramilitary operations, operated that drone from the French country of Djibouti, and killed 6 persons in a car in Yemen where there was no armed conflict going on. So that was not a secret. The Los Angeles Times did 2 full stories in 2 different issues of their newspaper reporting on it. The UN Special Rapporteur for Extrajudicial Killing, Asma Jahangir from Pakistan, reported in January 2003 to the United Nations that that killing in Yemen was an extrajudicial unlawful killing. So January 2003, a year or more before we publicly became aware of the use of torture. So why has it been so much harder to end this blatantly, this expert determination that the use of drones outside of armed conflict zones to fire Hellfire missiles is unlawful? As you've heard from a number of the other speakers, part of the problem is that within both international and domestic law, as well as the mainstream teaching of the three principal religions represented here, Christianity, Islam, and Judaism, killing is not an absolute prohibited act as torture is. So we have to make a more sophisticated case to end this form of killing, which is absolutely prohibited. We have to distinguish it from those areas where we can't necessarily bring the law on our side until we get the law completely in support of a more pacific teaching from our major religions. But I think the other reason why it's more difficult is not necessarily even this tangible problem within law and religion, and I hope to speak about both in my very brief time here today. Also, by now, perhaps as a result of the fact that killing is not per se absolutely prohibited, or other reasons, popular culture, not only in the United States, but around the world, has bought into an ethos of militarism that has created a sense where if you say to somebody, and I'm sure many in this room have had this experience, but killing with drones in Yemen or Somalia is unlawful, people say, you've got to be kidding. As Gabor said, there are bad guys in Yemen. We have to kill them or they'll kill us. We kill them there, they kill us. That is considered the wisdom of our time. That's considered good because we're keeping ourselves secure and security is good. Or we're stopping people who would harm others and that's a good. So everything we do, our entertainment, so many other things are around this idea that military answers, as Bishop Pate said last night, we see we have a giant hammer and we want to make it bigger because we have come to see the world full of nails. So the drone has just added to this. It's the high-tech, it's the sleek. It gives the president a very low-cost way of buying into and being part of this widespread understanding that this kind of killing is somehow not just wrong, not just for the exceptional situation, but a way of showing how powerful, how exceptional the countries that use drones for killing are. The seductive quality of killing with drones has led international lawyers, ethicists, and even theologians to present arguments in which they find the law and the Bible supporting killing with Hellfire missiles launched from drones. And I would just suggest to you that this has been a very short period of time so that I think we can have some hope that we can turn it around. These arguments that we are hearing today from just war ethicists, from international lawyers, would never have been made during the Cold War. So we're talking about a period of time from 1990 until today. It should not be so deeply entrenched that we cannot turn it around with efforts like the ones we're talking about here today. So let me give you just a brief account of what international law actually says and how I understand the authentic just war theory to mutually support the broadest and most robust restrictions on killing as a way, and then maybe at the end I'll just offer an idea of how we can perhaps re-inspire the world to think about those restrictions as the good, the killing as the evil. International law has a very well-known rule at the heart of the United Nations Charter, Article 2, Paragraph 4. It imposes a broad and general prohibition on the use of armed force by states. Unfortunately, I see in my area of expertise the law governing resort to force. It's distinctive from what you heard from Gabor and Wendy talking more about the law on the battlefield. But the law with regard to resort to force, we find today in journal after journal, in talk after talk, that international lawyers want to find exceptions, increasing exceptions to get around the prohibition. This is the focus. I wrote recently that the American Journal of International Law, one of the leading professional journals in the field of international law, has published 5 articles in the last 6 years, each of which argues for a broader right, a broader interpretation of the UN Charter to allow more killing. Not a single one in response to that view. This is the common thread today. Not only do we not see strict interpretations of the Charter as written that would result in restraints, far greater restraints on the use of force, we have not seen a single move to expand the scope to prevent more armed conflict under the Charter since it was written in 1945. Not a single move. For example, to prohibit under international law resort to military force within a country, namely against civil war. Civil war does not have a specific rule in international law against it. But Article 2.4 could reach even a civil war because it says all use of force is prohibited. It is a broad prohibition that prohibits every kind of significant military force above a de minimis level, above the police force level, for example, where a police vessel might shoot across the bow of a fishing boat that is catching excessive amounts of fish. The Charter itself actually has only 2 express exceptions to this broad and powerful prohibition on the use of military force in international relations. It has a very narrow exception for self-defense. Article 51 of the Charter says that if a state, a sovereign state, is the victim of an armed attack, in that situation, it may defend itself with military force on the territory of the attacking state and may invite others in to assist it until the Security Council acts. The International Court of Justice has further restricted Article 51 self-defense and has pointed out that that armed attack must be a significant armed attack. And it has pointed out that under the rules of state responsibility, you can't just, if a terrorist group launches an attack on your country, you can't attack the state where that group is simply because they're there. That attack has to be the responsibility of that state. So when the United States attacked Anwar al-Awlaki with a Hellfire missile, we had no basis in the law of self-defense, despite what President Obama said, to justify that. There was no attack on the United States from Yemen. The attacks that the United States alleged that Mr. al-Awlaki was planning were somehow in the future. They had never taken place. But even if they did take place, Yemen wasn't responsible for them. And they would not have been significant enough to justify military force. Police action, yes, of the kind that we used to carry out in cooperation with Yemen when al-Qaeda first started attacking in this country and attacked our Navy vessel, the USS Cohn, in the harbor of Aden in 2000. We sent the FBI. We could always do that, but not Hellfire missiles, not under Article 51. The other express exception is also quite limited, and that's when the Security Council authorizes the use of force. But the Security Council, even if it is assessing whether it would be lawful under the Charter, it has to determine that the use of force would be a last resort and that it will promote peace and security in the world. International law, as the International Court of Justice has told us, every use of force, and really every forceful action, whether it's sanctions or other kinds of coercion, must, prior to their being implemented, be responding to an unlawful action and be necessary to bring about an end to it as a last resort, because other peaceful means do not work, and only cause proportionate harm in the course of reestablishing the legal situation, responding to. This analysis is really only open to the Security Council when it's authorizing force or to a state that has been attacked by another sovereign state. This law of the Charter does not support what the United States and other countries have been doing with drones. In addition to these specific rules on resort to force, we never forget in any situation that the United States or any country is involved in that human rights law is always part of the calculus. Nevertheless, despite these narrow and important rules restricting the use of force, as I mentioned to you, there seems to be some kind of favorite occupation among law professors and our students to write articles seeking to expand the right to use force in self-defense, and to even come up with alternatives to the Security Council for self-authorization. Let NATO authorize, or democratic countries can authorize. No, this is not what the law requires. And in 2005, just 10 years ago, the world came together after the 2003 unlawful invasion of Iraq, at the invitation of the Secretary General of the UN, completely reviewed the UN Charter principles and the operations of the United Nations in general, and agreed in September in New York of that year to reconfirm the Charter as written and to strictly comply with the principles of the Charter on peace. Now, that was 2005, just 10 years ago. So what I have just stated to you is the law. There was the preliminary report of the panel that the Secretary General asked to review the Charter and the operations of the United Nations in general concluded that the only use of force that can be considered lawful and legitimate in international relations conforms with the Charter. This has to be the case because the UN Charter and international law in general is the common code of humanity. This is what we everywhere have in common. We do not have one religious faith. We do not share one ideology. We do not share one ethical approach to these important questions, but we do share international law. That document, which reinforced this view and reestablished that for all of the world, all sovereign states are committed to the Charter and its rules on peace, did have some language, some commentary that I'm afraid helped spread the idea of use of force as a good. It was only commentary, but it was around this idea that military force could be good and useful for defending human rights. And that was a very short, I thought we had 20 minutes. All right, I see your 5 minutes. I'm going to go into hyperspeed now. But France and the United Kingdom, by 2011, were pushing for the use of force in Libya. And they, in the United States, joined them using drones there, arguing that they would protect civilians. But even in this case, you see that no negotiation was tried to protect civilians within the Libyan civil war. And the excessive use of force ended up within 4 months that NATO killed 30,000, NATO was part of the killing of 30,000 people in Libya. And a civil war began that has not ended. So military force should be dissociated, the whole idea, with any possibility of good. We have data from the USIP and other scholars showing that intervention, military intervention, either in civil wars or for counterterrorism, do not lead to positive outcomes. And while this data clearly supports the legal and moral case against the use of military force, it is irrelevant to anything but the Security Council's own legal assessment of the success of authorizing intervention or a state assessing whether it should go to war when it has actually been attacked and has a right of self-defense. I was going to talk in some detail about how international law and the use of force is commensurate with and tracks the Roman Catholic just war doctrine. In fact, the Catechism sets a bar above the minimum requirements of international law. The injury that a state suffers must be lasting, grave, and certain, and the response must not inflict evils and disorders graver than the evil to be eliminated. Moreover, the Catechism only refers to aggression and defense, not force for these reasons that the Security Council might authorize: human rights, arms control, or counterterrorism. Logically, therefore, an ethical leader in a case of self-defense, or the Security Council as the right authority for all other cases, needs to first consider the law on resort to force, and then, if resort would be lawful, whether it also meets moral teaching. In other words, there's a two-level hurdle before resort to force could possibly be acceptable. Yet, scholarship advocating resort to force indicates a widespread disrespect for the authentic international law against force, an attitude that, in my view, can be traced to just war scholars who take little or no notice of international law in shaping their assessments of the morality of armed force, and who have in turn been influenced by the realist school of reliance on military force. Today's international legal regime against the use of force, especially the peremptory norm against serious violations of Article 2.4, is not only the law, it is the basis, it is the minimum basis of morality. In other words, for a war to be just, it must at least be lawful. To go to war in violation of the UN Charter is both a legal and a moral wrong. This means that the peace regime of international law presents a set of rules that is not only helpful as a general matter for fulfilling moral obligations, it forms the first step toward fulfilling those obligations when it comes to war. I was going to go on, but I know I'm out of time, to talk about some of the theories of people like Jean Bethke Elshtain of the University of Chicago, who talked about moral wars without taking into account international law or getting it wrong. Even Princeton's Michael Walzer, widely respected as an ethicist, and yet he does not take international law seriously into account in his justification of going to war. But by the 1980s, David Hollenbeck, the Jesuit of Boston College, had been trying to and arguing for reversing what some of these ethicists in the area of just war have done. He pointed out that the moral presumption from Aquinas and other of our great moral thinkers presumes that war is sinful, and the presumption is that war should always be a last resort. Hollenbeck wanted to reshift this presumption. Against war, always the last resort. I'm sorry to say that until now he has failed. I'm not sure what it will take to get people to get this presumption right again. I myself have been thinking while I'm here at Princeton about what will end what Pope Francis called the madness of war, or the madness of militarism. I don't think looking strictly at the law, and I'm making my final sentence here, looking strictly at the law, or even the history or the counterproductivity of military force to solve so many of our problems will help. I do think going back to Aquinas and his support and belief in the role of law in human flourishing will be helpful, but more than that, for what he told us about the transcendentals, of what is truly the good, the true, and the beautiful. He said that which is beautiful is true and good, and it has the qualities of clarity, integrity, and proportion. These are the very qualities of good law, like the law against the use of force. In a sense, it would be poetic justice, a beautiful justice, if a return to the concepts of Aquinas, regardless of our religious beliefs or understandings, revived a love of peace and a view that peace is the beautiful.
So next I'd like to invite to speak Professor Marjorie Cohn, who's at the Thomas Jefferson School of Law. She's also the former president of the National Lawyers Guild, and she's renowned as a lecturer on international human rights and U.S. foreign policy. She also consults for CBS News, legal analyst for Court TV, and has had numerous appearances on television as an expert commentator. So please come up to the podium. Thank you.
Thank you so much for inviting me to this terribly important conference. And I know why I was invited, and that is because I'm from San Diego, which is where General Atomics is located, and General Atomics makes the Predator and Reaper drones. So I think I'm eminently qualified to speak at the conference. In his 2009 acceptance speech for the Nobel Peace Prize, President Barack Obama declared, "Where force is necessary, we have a moral and strategic interest in binding ourselves to certain rules of conduct. And even as we confront a vicious adversary that abides by no rules, I believe the United States of America must remain a standard bearer in the conduct of war." By the time Obama accepted the award, 1 year into his presidency, he had ordered more drone strikes than George W. Bush had authorized during his 2 presidential terms. The Bush administration detained and tortured suspected terrorists. The Obama administration has chosen to illegally assassinate them, often with the use of drones. The continued indefinite detention of men at Guantanamo belies Obama's pledge 2 days after his first inauguration to close the prison camp there. However, Obama has added only 1 detainee to the Guantanamo roster. According to John Bellinger, who formulated the Bush administration's drone policy, this government has decided that instead of detaining members of Al-Qaeda at Guantanamo, they are going to kill them. In 1976, President Gerald Ford issued an executive order banning political assassinations. It said no person employed by or acting on behalf of the U.S. government shall engage in or conspire to engage in assassination. And yet assassination is central to U.S. war strategy with the militarization of our foreign policy. By classifying terrorism as an act of war rather than a crime, the Bush administration claimed it was no longer bound by its legal obligation to provide due process. Killing is more convenient than capture, and this killing takes place with drone strikes, assassinations by special forces, etc. Osama bin Laden could have been captured and brought back and tried. Everyone was unarmed when the special forces arrived. And when people ask me about, well, these terrorists are horrible, they want to do us harm, why should we worry about due process? I remind them that after the Holocaust, after World War II, the victorious powers got together to decide what to do with the Nazi leaders. And Winston Churchill said, just take them out in the backyard and kill them all. And to his credit, Justice Robert Jackson, who had taken a leave from the U.S. Supreme Court to be chief U.S. prosecutor at Nuremberg, said no. If we do not provide due process, even to the Nazi leaders, and no one in the history of the world has committed, well, I don't want to say the history of the world because I'm not an ancient historian, but I can't think of anyone who has committed worse crimes than the Nazis. He says, if we do not provide due process, even to these Nazi leaders, we will be passing a poisoned chalice to future generations. The Cold War converted war into a global battlefield. CIA covert operations took place in foreign countries against communism. And we had what was called the Salvador option at the end of the Cold War, where the United States sent CIA and special forces to create, arm, finance, and assassinate, teams and death squads to assassinate while avoiding U.S. casualties and avoiding public opposition to U.S. ground troops. With the deck of cards during the Bush administration, which were during Operation Iraqi, so-called Iraqi Freedom, the 52 top wanted Iraqis, assassination became a key component of U.S. war strategy. Targeted killing against someone not convicted of a crime is an extrajudicial crime outside of any legal process, and it violates both international human rights law and international humanitarian law. In my book, and I'm not touting it because I don't think there's any copies left to buy, but you can always buy it on Amazon if you want. It's a collection of essays by different people. It's called Drones and Targeted Killing. It's right up the alley of this conference. One of the writers in the book is an Israeli named Ishai Minuchin, who was one of the original refuseniks from the Lebanon War. He's the executive director of PACADI, the Public Committee Against Torture in Israel. And in his chapter, he says that assassination is sometimes sanitized with euphemisms such as targeted preemption, preemptive preemption, extrajudicial punishment, or targeted killing, suggesting that the assassination has hindered a bad event. It was just surgical punishment or a military operation, and in the United States we call them surgical strikes. You just go in and get that little tumor and come right out, and it's great. Despite, and this is Minuchin, despite the hesitance of Israel to use capital punishment, assassination has been a covert military practice for many years. And he says that Israel also uses assassination as revenge or to deter or send a political message. Also in the book is an essay by Richard Falk from Princeton. He is emeritus from Princeton, was here for many, many years. And he says, or he wrote, until the Cheney-Rumsfeld embrace of secret war by assassination, the United States didn't follow Israel's adoption of terror to fight terror, which had evolved from the shadows of Israeli policy to an outright avowal of legality in 2000, after years of disavowal. Until the leak of the Department of Justice white paper in 2013 saying that U.S. citizens could be targeted, Americans weren't too concerned about the targeted killing of foreigners. And for one thing, it's sanitized in the media. We don't hear the stories of the drone victims. We don't see the images of what our drone bombs do. But when this white paper was leaked, people were very outraged. Rand Paul mounted a 13-hour filibuster of John Bellinger's nomination to be CIA director, and this motivated Archbishop Desmond Tutu to write a letter to the editor in the New York Times where he said, "Are you trying to say that American lives are more valuable than our lives?" And when I saw that letter, I decided that I wanted Archbishop Tutu to write a foreword to the book, which he did, and he elaborates on that whole issue of American exceptionalism. And we hear that a lot. We hear it from Obama. We heard it in the State of the Union address. America is exceptional. We're better than everyone else. And that justifies whatever we have to do to make sure that we remain on top. Number one, the world's leader. This Department of Justice white paper said that consent makes a lethal operation in a foreign nation legal. So if Pakistan or Yemen or Somalia consent, then it's legal. But UN Special Rapporteurs Philip Alston and Christopher Hines have said that consent does not absolve either of the concerned states of their obligations to abide by international human rights and international humanitarian law. A state cannot consent to a violation of international law. The Department of Justice white paper said that lawful killing in self-defense is not an assassination, that a lethal operation against a U.S. citizen whose conduct poses an imminent threat of violent attack against the United States would be a legitimate act of national self-defense and would not violate the assassination ban. So this imminence, what is imminence? Well, under the Caroline case, imminence means the necessity for self-defense must be instant, overwhelming, leaving no choice of means and no moment for deliberation. But the white paper says that a U.S. citizen can be killed even where there is no clear evidence that a specific attack on U.S. persons and interests will take place in the immediate future, unquote. So what does imminence mean? Now, we hear a lot about how, well, drones minimize civilian casualties. This is one of the reasons it's Obama's weapon of choice, that and that Americans don't get killed. But a study based on classified military data conducted by the Center for Naval Analyses and the Center for Civilians in Conflict found that the use of drones in Afghanistan had caused 10 times more civilian deaths than manned fighter aircraft. I want to say a few words about the morality of drone strikes that are not conducted during armed conflict. The Martens Clause from the Hague Conventions requires that a means of warfare be evaluated in terms of the principles of humanity and the dictates of public conscience. Jeff McMahon has written that targeted killing by drones of terrorists planning wrongful attacks is morally similar to the killing of aggressor combatants who are asleep, the sleeping soldier, who is a future threat but not a present threat. It's like treachery, which is prohibited by the Hague Convention, poison weapons prohibited by the Hague Convention. Not all's fair in war. I don't know about love, I'm not an expert on that. But as Professor Waldron said, Kant condemned assassinations, poisons, and lying in wait. Harry van der Linden, who's the philosopher who writes about just war principles in the book, talks about drones as deadly surveillance platforms. He says a drone killing is not like a surprise attack on a sleeping soldier. Rather, the drone operator is like a soldier standing in the closet of a sleeping enemy soldier, watching him tossing and turning, going to the bathroom, getting a smoke, falling back to sleep. And then after many hours, the soldier steps outside the closet and pulls the trigger. And the enemy soldier had some sense of being watched. The sound of drones may be heard overhead. But being unable to verify his suspicions, he fell into a restless sleep, never fully knowing what hit him. By the time the hissing sounds of missiles are heard by their victims, the deadly impact is only seconds away. There has been reference to the targeted killing of Batila Masood, a senior Pakistani Taliban, on August 5, 2009. After the drone watched him for several hours, he was finally killed on the rooftop of his father-in-law's home. And at the moment of the strike, Masood was receiving dialysis from kidney disease. Also present were his father-in-law, his mother-in-law, his second wife, and 7 bodyguards, all killed. It was as wrong to kill him as it is to kill mourners at a funeral. There's been reference to the double tap, where we go in, a drone strike, a drone bomb hits, some people are killed, some people are wounded. The rescuers go in to pick up the wounded, and then the rescuers are droned and killed. And then it really should be called a triple tap, because then when they go to the funerals to mourn their dead, then there's a third strike, the triple tap. Harry van der Linden said, what seems to make drone killings at times morally deeply problematic is that the operators become familiar with the targets as a person, watch his everyday life, his home, even his family, and then the kill occurs. Thus, it seems that a person is killed rather than a combatant or a human with hostile intention. Michael Walser talked about the naked soldier cases in the just war tradition and gave some examples. During World War II, a sniper sees through a telescope a German soldier taking a bath and decides not to shoot him. During the Spanish Civil War, George Orwell refrained from shooting an enemy soldier running while trying to keep up his pants. And during World War I, an Italian soldier refrained from shooting Austrian soldiers who were drinking their morning coffee and enjoying a smoke. Van der Linden says, van der Linden says, the extreme asymmetric killing as it is currently practiced by the U.S. cannot be separated from the colonialist, racist, and imperialist symmetric killing of the recent past. Huey Steinhoff wrote, those black, yellow, or brown people might therefore have a somewhat different perspective on the alleged advantages by drones. They might think that it is bad enough to be treated like the barbarian enemies, but still worse to be treated like cockroaches on the receiving side of pest control. In 2009, when Jane Mayer wrote an essay in The New Yorker, and it was called Predator War, it's reprinted in the book. And it was the first comprehensive expose of the U.S. drone program. And Jane Mayer interviewed Vicki Duvall, who was a former CIA lawyer who now teaches at the U.S. Naval Academy in Annapolis. And Vicki Duvall said, people are a lot more comfortable with a predator strike that kills many people than with a throat slitting that kills one. And sure enough, when we heard about the horrific throat-slitting beheading of the 2 American journalists by ISIS, there was hardly a peep when Obama said, I'm going to start new wars and extend my war in Iraq and start a new war in Syria, and everybody said, great. But we don't see the pictures of the children blown up with drones, their arms there, their legs there, their head there. If we did, just like we did during the Vietnam War, remember that iconic photo of the 9-year-old girl running naked from a U.S. bomber that had just dropped napalm all over her. And that was the moment that I became a lifelong anti-war activist when I saw that picture. They're very, very powerful, these images. It's been said that the war on terror is a misnomer, and it is a misnomer. Terrorism is a tactic. It's not an enemy. You don't declare war on a tactic. And yet, under the guise of the so-called war on terror, the Bush administration, and to a certain extent also the Obama administration, has shredded the Constitution. There will be no accountability. Accountability will be the only way that will deter future presidents and future administrations from committing the war crimes. And when I say war crimes, I include torture, which is a war crime. Many of you have read this summary of the Senate torture report, which is horrific. I've been writing about torture for years, books and articles. Nothing prepared me for that report. Rectal rehydration and the things that we do to other human beings. And yet Obama said we have to look forward, not backward. These things happen in the past. Well, crimes always happen in the past by the time they get prosecuted. And he refuses to bring these war criminals to justice. And I'm talking about the Bush, Cheney, Rumsfeld, Rice, the legal mercenaries, John Yoo, Jay Bybee, et cetera, and the CIA directors and the Department of Justice, the attorneys general. And perhaps one day there will be the next Senate report on drones, and then Obama could conceivably be prosecuted as a war criminal, if not in this country, then in other countries under universal jurisdiction, or in the International Criminal Court, although there are some jurisdictional issues there. After 9/11, it really baffled me how 19 men could commit suicide and take 3,000 innocents with them. I just could not understand it. It certainly was not our democracy they were objecting to, or they would have aimed at the Statue of Liberty. So I went and read what Osama bin Laden had written, and I'm no fan of Osama bin Laden's, mind you. And there were 3 pet peeves that Osama bin Laden had. First of all was the presence of foreign infidels, U.S. troops in the holy Muslim sites of Mecca and Medina in Saudi Arabia. Secondly was the killing of 1 million Iraqis, half of them children, by the sanctions that were backed by the U.S., specifically Bill Clinton. And the third was Israel's treatment of the Palestinians. Until we completely reassess our foreign policy, we will never be safe from terrorism. And that means refraining from illegally invading other countries, killing their people, torturing their people, illegally occupying their lands, uncritically supporting other countries that illegally occupy other people's lands. Until we do that, everything else is Band-Aids. We will never be safe from terrorism. We will always be vulnerable to terrorist attacks. Thank you.
So our third and final speaker is Pardis Kebriai, who's a senior staff attorney at the Center for Constitutional Rights. She has been working on challenging government abuses post 9/11, including in the areas of targeted killings and unjust detentions at Guantanamo Bay and in the federal system. Thank you, Pardis.
Hi, everyone. Thank you very much. Thank you to Reverend Killmer for inviting me to be here. I'm a lawyer at CCR at the Center for Constitutional Rights. I was asked specifically to address the sort of discrete aspect of the targeting of U.S. citizens. CCR and the ACLU brought litigation challenging the drone killings of 3 U.S. citizens in 2011. So I was sort of going to describe that litigation and talk to you about the state of legal accountability in the United States, which is pretty bleak. But just for context, in terms of just casualties and impact, U.S. citizens represent less than a fraction of people killed and injured as part of the U.S. drone program outside of Afghanistan since 2002. If you look at the numbers of a group called the Bureau of Investigative Journalism, which has documented exhaustively killings over the past decade, there have been as many as 5,600 deaths in Yemen, Pakistan, and Somalia alone since 2002. To our knowledge, 4 of them have been American citizens. They were Anwar al-Awlaki and Samir Khan, who were killed in drone strikes in September 2011 in Yemen. 2 weeks later, Anwar al-Awlaki's 16-year-old son, Abdul Rahman al-Awlaki, who was killed in October of 2011. Another American whose name is Jude Keenan Mohammed, who's gotten far less attention, who was killed in November of 2011 in Pakistan. And then early last year, we heard media reports of a 5th American who had been authorized for killing in Pakistan. So really a minuscule sort of impact in terms of impact. We don't have a good picture, as has been said earlier today, a good picture of the human costs or impact on the side of drone operators, and I think that's significant in terms of psychological impact. But the fact that most of the human costs on the drone end, on the other drone end, are remote from the standpoint of the majority of Americans, not only in terms of location, but in terms of identity, and this has been talked about today, is, I think, one of the challenges we face in making the US public care about what we are doing in other countries. To the extent the public is concerned, they care more, not surprisingly, when the impact hits closer to home. So it was telling, as Marjorie was just talking about, that the greatest moment of public debate we have had in this country about this program was when the white paper, the Justice Department white paper discussing the legal authority to kill American citizens was leaked in early 2013. By that point, by February of 2013, there were as many as 4,000 people who had already been killed. And that is when we as a country sort of began talking more publicly about this program. It was after that leak, after Rand Paul's famous 13-hour filibuster railing against the president's claimed authority to kill Americans, that support for drone strikes dropped to their lowest point yet. So at that point, if you look at Gallup polls, with all the caveats about polls, but the majority of Americans, 52% at that time, said they opposed drone strikes against US citizens abroad, so a majority. And opposition reached 79% when the question was about the possibility of strikes against Americans on US soil. The only circumstance under which those polled supported drone strikes was when they were used against foreign citizens on foreign soil. Under that scenario, 65% were in favor and 28% opposed. Clearly, we tolerate torture and inhumanity right here. If you look, there are many examples we could talk about. If you look at One other issue I work on, solitary confinement in US prisons. The majority of the public still believes that prolonged isolation of people 22 to 24 hours a day for decades is an acceptable form of punishment, despite that under the law, that is torture. That's recognized as torture. But I do think that distance, geographically, culturally, religiously, and in terms of national identity, are in the mix of factors, along with fear, fatigue, and then, of course, secrecy, that we have to bridge in reaching people and making them care and pay attention. I think transparency, and this is something I've come to feeling sort of over the past decade of working on torture and detention, I think transparency and more information is essential, but I don't think that is the main obstacle, actually. I think we know quite a bit. There is a difference in having government information, but we do know quite a bit about this program and the impact over the past 10 years. So I don't think it's just a lack of information that is keeping the public at large, I think, from taking action. So just given the sort of very disparate impact of this program in terms of US citizens, foreign citizens, at CCR, we faced a certain moral question when the authorization for the targeting of Anwar al-Awlaki, an American citizen in Yemen, was leaked to the press in 2010, which was, in a world of our limited resources, do we pursue a legal case on behalf of the family of that individual, or do we go forward with the legal challenges we've been thinking about on behalf of Pakistani civilians who were dying in huge numbers at that time and who continue to be bearing the brunt? In our view, the legal violations were equally clear. So under international law, the United States is bound to respect constraints on the use of lethal force irrespective of citizenship. If you look at the text of the Due Process Clause of the Fifth Amendment in the Constitution, it applies to persons, not exclusively citizens, and there is Supreme Court precedent for the extension of those protections abroad to the conduct of US actors operating abroad outside of the mainland of the United States. But the difference was that when it comes to enforcing those rights, citizenship has been a plus factor. It is not dispositive by any means. There have been cases brought by US citizens in other contexts that have been dismissed the same way that foreign citizen cases have been dismissed. There have been groundbreaking victories on behalf of foreign citizens despite non-US citizenship, but citizenship can matter. So when we were sort of, just in terms of it's been a plus factor in terms of jurisdiction, and jurisdiction, which is basically the opportunity to be heard, simply to be heard in court, has been the challenge in national security cases over the past decade in the context of torture, detention, killing, rendition. There have been over a dozen cases brought, and in every single case, virtually every single case, the government's knee-jerk response has been to dismiss on various arguments relating to the risk to national security, the need for secrecy, executive supremacy. So our calculus at the end of the day, and it was a very difficult decision, was that given the possibly greater chance that our clients could actually be heard and have a day in court, regardless of the outcome, that we would pursue the case, the al-Awlaki litigation, and we did that with the ACLU. We ultimately brought two cases. So there was one challenging the authorization for the killing of Anwar al-Awlaki before the fact. That was in 2010. And then there was a second case that we brought after a drone strike killed him in a car in Yemen, along with another US citizen, Samir Khan, who I mentioned, killing both of them. And the government has said only about Samir Khan. It's gone on for pages and pages about its accusations against Anwar al-Awlaki, and some very serious ones about Samir Khan, who also died. It has said only that he was not specifically targeted. That strike killed two Yemeni citizens as well, who we don't talk that much about. And then 2 weeks later, 16-year-old Abdul Rahman, Anwar al-Awlaki's son, was killed as he was having a meal outside in plain view with his teenage cousin, a 17-year-old, having dinner when a missile fired on them, killing them and at least 6 other people. About him, the United States has also only said that he was not specifically targeted. It has said nothing else about that 16-year-old boy's death, who was born in Denver, Colorado. So our second case was challenging after the fact the legality of all three of those killings on behalf of their families. Our legal theories in those cases were pretty similar, and they were not radical, despite the controversy that the litigation generated. It was not that the United States could not use lethal force under constitutional and international law, but it was simply that any use of force had to respect the law. And we said that the general rule under constitutional and international human rights law is that states are prohibited from killing without due process, except in the face of an imminent threat, where imminence incorporates a requirement of specificity. There has to be a specific and imminent threat, and lethal force is a last resort in the face of that threat. The only exception to that universal general rule is in battlefield circumstances, where the exigency of the conditions permits a certain loosening of the rules, though still not without constraints. So in 2009 and 10 and 11, when Anwar al-Awlaki was being targeted and then killed, we said that there was no battlefield in Yemen involving the United States. And even accepting the US's global war paradigm, that it was involved in a global war against al-Qaeda, that al-Awlaki was the specific group, you had to sort of be specific and look at the specific allegations, and Anwar al-Awlaki was alleged to be part of a group that was said to be associated with al-Qaeda, not al-Qaeda proper. And while that group may have shared at that time anyway, a certain ideology with al-Qaeda, there were not the sort of structural links that were required to make it an associated force. So under those two theories, we said his targeting would fall outside of an armed conflict war type situation that might justify his killing, that the law that should apply are the general rules, where lethal force has to be after due process or in the face of an imminent threat as a last resort, and that his killing was unlawful, or that if it was carried out, it would be unlawful. In that first case, we also included a claim about his right to notice under the Fifth Amendment, under due process, that he had a right to notice of the criteria that could make him subject to killing. And as we know, the criteria and the legal standards for targeting of US citizens and foreign citizens remain opaque. We have a white paper, we have a heavily redacted legal memo from the Justice Department, and we have a crib sheet of policy standards. That is what we have after a decade. The government's responses were also similar to both cases. They moved to dismiss both. The Obama administration's stated position is that it believes judicial review of any targeted killing operation is inappropriate. It has stated that publicly, and it exercised that position in court. In the public realm and in their internal memos, the government acknowledges that US citizens retain their due process rights abroad. So in his speech at the National Defense University in May of 2013, President Obama said that he didn't believe it would be constitutional for the government to target and kill any US citizen with a drone or a shotgun, he said, without due process. So there is recognition that we retain our rights abroad as well as here. It's just that due process doesn't mean judicial process as far as the government is concerned. So when it comes to killing people outside of recognized or traditional battlefields, due process does not, in the government's mind, require charge and trial necessarily. So that's sort of its stated position publicly in court, in its papers in court. The government did indeed argue that even accepting that Anwar al-Awlaki, Samir Khan, and Abdul Rahman retain their Fifth Amendment rights, and that there might have been a violation, that it would be inappropriate for the court to actually review their claims because of national security considerations. The court, unfortunately, also responded similarly to both of our cases in accepting the government's arguments and dismissing those cases. In the first case, the court said, the court held that the question of whether carrying out the standing order to kill Anwar al-Awlaki would violate his constitutional rights, his Fifth Amendment due process rights, was a political question, not a court decision. It was a political question reserved for the executive and Congress, even while the district court judge acknowledged that that ruling was unprecedented, to say, just as a sort of a matter of common sense, to say that a constitutional claim alleging by a U.S. citizen the violation of his due process rights for his killing by his government was a question reserved to the executive. Recognized that that was an unprecedented ruling, but went ahead and dismissed the case. In the second case, the court sort of interestingly rejected that broadest of the government's claims and said that no, there is nothing inherently inappropriate about a court exercising judicial review of constitutional claims by U.S. citizens against their own government, but that it would exercise its discretion in deciding that it shouldn't have a role. So she found, the district court in our second case, which was after the fact of these killings, said that there may have indeed been a violation of Anwar al-Awlaki's due process rights, but that she wouldn't decide whether there had been a violation and whether he was entitled to a remedy because of national security factors. And with respect to Samir Khan and Abdul Rahman, she simply found that they had not demonstrated a violation at all because they hadn't been intentionally targeted, despite the fact that drones deliberately, intentionally fired on their heads. So she said there had just been no plausible stated Fifth Amendment violation at all. So in the end, after years of subjecting themselves to scrutiny and reliving their grief, our clients decided not to pursue an appeal. And the cases ended there at the district court level. So accountability has been very challenging in all national security contexts, not just in the targeted killing context, but it is important to be clear that it remains an open question in this context because the only litigation that has been brought has only gone as so far as the district court level. And there is quite strong Supreme Court precedent for the unconstitutionality of what the government is doing. It's just that cases haven't gone that far. And then Supreme Court review is discretionary. You don't have a right to go to the Supreme Court. So whether cases actually even go that far remains a question. So at this point, legal accountability with respect to this program remains elusive in the United States. Political accountability is at best checkered. Most members of Congress remain in the dark about the full scope of this program. Until 2 years ago, the committees that are tasked with oversight hadn't seen the full legal memos discussing the killings of U.S. citizens. And then there is no meaningful public accountability because to this date, the government continues to hold back its own data about how many people have been killed, who they are, where it has happened, the legal standards, even basic acknowledgement. So the 4 U.S. citizens I talked about at the beginning, I think there have been half a dozen cases that the United States has acknowledged publicly, officially. 4 of them are of U.S. citizens. And meanwhile, these drone strikes continue. I think there's a real, in terms of the law and the landscape, a reassessment we sort of need to make at this point in light of a shift of operations in Iraq and Syria and changed facts on the ground in Yemen. But there are still real legal problems with this program, and drone strikes continue. And this month alone, over the past 3 weeks alone, 31 people died in Pakistan. And all we know is that they were militants, according to press reports. Just a quick word about other accountability with respect to civilian casualties. Just as a starting point, accountability, separate from judicial and legal accountability, would mean just disclosing basic information in situations where credible, plausible allegations of civilian harm have been presented. The United States has an obligation under international law to to investigate and then to publicly explain in a meaningful way the results of its investigation. That has not happened. To take one case in point, there was a U.S. drone strike in Yemen in December of 2013 on a wedding party that killed 27 members of that party traveling in a wedding procession. Officials acknowledged, and that's a strike that has been documented by Human Rights Watch and other journalists and advocates, in response to allegations of civilian deaths. The government acknowledged the strike. It acknowledged that it said it was investigating, but it has to date failed on the record to say anything about the results of its investigation, and has denied, in fact, officially, that there were civilian deaths. In this void of even that basic kind of accountability, fortunately, international mechanisms have started filling the void. It's not enough. The United States bears the primary responsibility for accountability, but there are international groups and UN mechanisms that are stepping forward to fill the void. So, for example, the Special Rapporteur on Counterterrorism, Ben Emerson, started an inquiry in the beginning of 2013, investigating claims of civilian casualties and sort of spelling out the legal requirements under international law for the United States and other states to investigate at least and publicly disclose the results of their investigation. The European Parliament and the UN Human Rights Council have over the past year and a half, issued resolutions building on that duty of transparency and accountability. So there are positive steps in the international realm, but we're sorely lacking domestically. Thank you.
When Faisal Shahzad was pleading guilty to trying to detonate a bomb in Times Square, he told the judge, this is in a statement, he told the judge, when the drones strike, they don't see children.
I've written an article on unlawful killing with combat drones in Pakistan that you might find interesting. It goes through the analysis, but one of the problems is this U.S. constant mantra that what we're doing in Pakistan is lawful because we either have some kind of consent, we're trying to protect forces in Afghanistan, we're involved in the civil war that Pakistan itself. Under international law, there is no lawful basis. So one thing we can do, and what I hope will be one of the tangible and as we heard from the previous panel, succinct responses, is to get behind authentic international law and moral prohibitions on killing. I hope that would help. Nothing else seems to. We all know there's plenty of data around of what the results, long-term results of US drone attacks have been in Pakistan, in Yemen, in Somalia, in Libya, in Iraq, and yet that doesn't seem to faze the American people, our leadership, our Congress. So perhaps if we come back to what this group can do best, morality based on our fundamental and commonly shared international law, that could help.
Just on the point of the effect of radicalizing populations, I think that's a little bit double-edged. And as someone, I know that's a point that we make, and I think it is true to some extent. But I think there's another dimension to think about as well. And as someone who's worked on Guantanamo, for example, that fear of radicalization and what will happen, I just think it's a little bit more loaded than we have acknowledged. And those arguments are the very kinds of things that are perpetuating some of these policies that make us feel like we need to do more or keep people detained. So I just would urge us, and I think I need to do more of my own thinking about how to sort of make that a little bit more of a nuanced message. But I think we can, sort of hold both and say that these killings are wrong just because it is simply they are unlawful, they are immoral, and they're just wrong, and not feel like we need to go to the security point as well. I think we can sort of hold both.
Yes, you're correct. The U.S. War Crimes Act does criminalize assassination. It's never been used, the U.S. War Crimes Act. Neither has the U.S. Torture Statute. Never been used. And we should push for our executive branch to use that. Also, the Universal Declaration of Human Rights is a moral document. It was codified in 2 legally binding covenants, and the International Covenant on Civil and Political Rights, which the United States has ratified, making it part of U.S. law under the Supremacy Clause, has that exact same provision that you mentioned. So I think it's better to cite the ICCPR as binding legal authority.
I don't really have anything to add except to apologize that I have really worked on trying to prevent torture and prevent targeted killing, and that focus, I have not focused on many of the other related issues, but I think if we shift away from this security-oriented cult worship that we seem to be in and shift to a return to respect for the rule of law, we will see respect for privacy. And I would say, you know, we do talk about the number of human beings killed in drone strikes. We don't talk about the injuries. We don't talk about damage to natural habitat, to wildlife, to homes, to infrastructure, but that is what is leading to the counterproductivity. It's lives lost and grief, but it's also this unbelievable amount of senseless destruction. So shifting that to a constructive, peace-oriented, law-abiding, ethical way of moving toward peace, I think is an answer to a lot of the problems we're facing, including privacy.
Just on Anwar al-Awlaki, you know, we're not criminal lawyers. We've not seen the government's information. I think our starting point is the power the government is claiming is the most consequential power any government could claim against people. It's the right to kill. And there are constraints on that power. There should be constraints on that power. And what we have seen publicly is prior bad acts, prior accusations, allegations in the public realm about involvement with Hassan, involvement with Abdul Muttalib, things that occurred in the past. And if there were prior crimes committed, he should be charged. People should be charged for crimes. The burden here is on the government to show a future imminent threat, something that justified using lethal force to kill him in advance, to authorize his killing in advance without charge and trial. So it was a matter for us of trying to hold the line on that standard. And I think the other danger of his case in particular is it's sort of been the government's been selling its program, I think, on the basis of people like Anwar al-Awlaki, people that it talks about as very bad guys, whereas the majority, well, we don't know the majority of those killed. They're sort of faceless, nameless people. There are thousands of people who've been killed, many civilians, and yet, you know, he has sort of been made the face of the government's program. So I think anyway, I think that's sort of dangerous in those respects. But our effort with the case was really to try to hold the line on the scope of the laws of war and due process protections under the Constitution and human rights law.
Imam, you've raised, I think, what is the essential question we have to address, and that's the one of culture. That's what's shifting us into these wrong views of the use of force, of the law, and so on. And that's my question. I turn around for you. Right now we've just been so negative. We've been negative all day today. I've come to the point after 12, 13 years of working on this problem to think we've got to think positively. What will attract people? What is more fun than the video game Call of Duty in which you kill to win? How about giving life to win? How about creating beauty to win? Let's attract people, especially younger people who are not as well represented here today as I would have hoped, to find that there's something more powerful and enjoyable and life-affirming than being involved in killing. To encourage my law students, there's something so much more, at the end of the day, reason to live than to find an exception to a loophole on some argument of imminence of why they can shoot a Hellfire missile at people. So that's the challenge we're at. And I'm just inviting people to finally open their minds, stop thinking negatively, stop saying no, and start finding the yes for all of us.
Thank you.